Okay, I wanted to read a little bit more about the difference between guardian ad litem and conservator. So, here it talks about the United States Family Law Courts guardians ad litem are not the same as legal guardians and are often appointed in underage children cases, many times to represent the interests of the minor children. Guardian ad litem may be called in some U.S. states court-appointed special advocates, CASA. Yeah, that's what they're called in South Dakota. They are the voice of the child and may represent the child in court, with many judges adhering to any recommendation given by a GAL. GALs may assist where a child is removed from a hostile environment, usually by the State Department of Social Services, and in those cases may assist in the protection of the minor child. Okay, before we get too far, I wanted to click on this. Ad litem. Ad litem, Latin for the suit, is a term in law used. I noticed that I'm not even. Okay. Is a term used in law to refer to the appointment by a court of one party to act in a lawsuit on behalf of another party, for instance, a child or an incapacitated adult who is deemed incapable of representing him or herself. An individual who acts in this capacity is generally called a guardian ad litem. Let's see. The United States legal system, which is directly influenced by the English legal system, continues to use the terms guardian ad litem and attorney ad litem. The term is also used in property litigation, where a person may be appointed to act on behalf of an estate in court proceedings. When the estate's proper representatives are unable or unwilling to act, the term is also sometimes used to refer to a judge who participates in only a particular case or a limited set of cases, and does not have the same status as the other judges of the court. This is more commonly called a judge ad hoc. It is particularly common in international courts and is rarer elsewhere. Click on ad hoc. Let's see. Ad hoc is a Latin phrase meaning for this. It generally signifies a solution designed for a specific problem or task, non-generalizable and not intended to be able to be adapted to other purposes. Compare a priori. All right. The terms a priori from the earlier and a posteriori from the later. Okay. I don't want to go that far. So, back to the difference between a guardian ad litem and a conservator. Let's read a little bit of this. A legal guardian is a person who has the legal authority and the corresponding duty to care for the personal and property interests of another person, called a ward. Usually a person has the status of a guardian because the ward is incapable of caring for his or her own interests due to infancy, incapacity, or disability. Most countries and states have laws that provide that the parents of a minor are the legal guardians of that child and that the parents can designate who shall become the child's legal guardian in the event of death subject to the approval of the court. Well, I think, let's see, mental health and probate courts. Guardians ad litem can be appointed by the court to represent the interests of mentally ill or disabled persons. The Code of Virginia requires that the court appointed a discreet and competent attorney at law or some other discreet and proper person to serve as guardian ad litem to protect the interests of a person under a disability. Guardian ad litems are sometimes appointed in probate matters to represent the interests of unknown or unlocated heirs to an estate. Okay, when a settlement is reached in personal injury or medical malpractice case involving claims brought on behalf of a minor or incapacitated plaintiff, courts normally appoint a guardian ad litem to review the terms of the settlement and ensure it is fair and in the best interest of the claimant. Okay. Don't see that I'm going to learn a whole lot more about that from right here. So let's go over to conservator. Let's see. It was already pulled up. Conservatorship. Conservatorship is a legal concept in the United States of America where a guardian and protector is appointed by a judge to manage the financial affairs and/or daily life of another due to physical or mental limitations or old age. The conservator may be only of the estate, meaning financial affairs, but may also be of the person when he/she takes charge of overseeing the daily activities such as health, care, or living arrangements of the conservatee. Conservatorship is established either by court order with regard to individuals or via a statutory or regulatory authority with regard to organizations. Of course, when referring to governmental control of private corporations, such as Freddie Mac or Fannie Mae, conservatorship implies a more temporary control than does nationalization. In other legal terms, a conservatorship may refer to the legal responsibilities over a person who is mentally ill, including individuals who are psychotic, suicidal, incapacitated, or in some other way unable to make legal, medical, or financial decisions on behalf of themselves. Conservatorship is a legal term referring to the legal responsibilities of a conservator over the affairs of a person who has been deemed gravely disabled by the court and unable to meet his or her basic needs of food, clothing, and shelter. There are two types of conservatorship: Lanterman Petrus Short and probate conservatorships. They are governed by the state's individual laws. Some states or jurisdictions refer to it as a guardianship or even a trustee instead of a conservator. I'm going to click on this. Lanterman Petrus Short Act of 1967. concerns the involuntary civil commitment to a mental health institution in the state of California. The act set the precedent for modern mental health commitment procedures in the United States. It cited 7 articles of intent to end the inappropriate, indefinite, and involuntary commitment of mentally disordered persons, people with developmental disabilities, and persons impaired by chronic alcoholism, and to eliminate legal disabilities. Let's see, to provide, to guarantee, to safeguard, to provide individual treatment. Let me speed read this. Okay, so a limited conservatorship usually refers to the limited legal responsibilities of a conservator over the affairs of an individual who is developmentally disabled but still capable of making important decisions for himself or herself. In these cases, the conservatee to whom the limited conservatorship applies can retain more control over his or her personal affairs than the other conservatees can. For example, he or she may retain his or her right to decide where he or she may live. Okay. An example of a conservator's duties include locating and marshaling assets. Place in proper rank, arrange in logical order, make ready for action or use, lead ceremoniously as in a procession. Okay, I guess marshaling. Marshaling assets, locating and marshaling assets. Yes, I need to marshal my assets. I think I need somebody to marshal my assets, such as property and money which belong to the conservatee, using the assets to buy food for the conservatee, secure and pay for placement in a facility, manage property, pay for insurance, mortgage payments, property cleanup, rent property, medical responsibilities, physician, medical need, on and on. In most states, an outside party or agency must review the facts of the case and submit a report, usually required to be in writing to the court before the court makes a decision on the request to establish a conservatorship or guardianship. Okay. In the United States of America, in some states, corporations can be placed under conservatorship as a less extreme alternative to receivership, whereas a receiver is expected to terminate the rights of shareholders and managers. A conservator is expected merely to assume those rights with the prospect that they will be relinquished. Let's see. Suggests that an insolvent bank should go into receivership rather than conservatorship to guard against the false hope and moral hazard. Somebody wrote that down. That's a pretty important thing. Okay. I think I kind of got the gist of what I wanted to know. Any comments?